Very good day to you, Dr. Asma. My name is Lee Garfield, matrix number 270605. First of all, I would like to thank Doctor for your time to review my presentation video for the second assignment of GRUP 4033 Civil Procedure 1. In the upcoming 10 minutes, I will be presenting the topics of the amendments of pleadings. Before I dive into the topics, allow me to briefly introduce the natures of pleadings in civil procedure. In its simplest form, the pleadings could be deemed as the foundation on which a claim is based on. The pleadings include all the written documents submitted to the courts that divulge the narrative of the litigant case. For instance, on the part of plaintiff or claimant, their pleadings include but are not limited to a statement of claim, reply to defense, and defense to counterclaim, whereby for the pleadings of the defendants, it ought to be a statement of defense and statement of counterclaim if there's any. Of course, these are not everything. As case deemed necessary, there may be other further pleadings such as a rejoinder incurred in a suit. All in all, it is to be reminded that the purpose of pleadings is to provide a permanent and exhaustive reference on the issues material in the dispute. The courts and the parties shall be bound by the pleadings to avoid either parties from being taken by surprise during the proceedings. Despite that, many a time that the litigants may found that there are factual inaccuracy from the outset, and thus it's necessary for them to amend their pleadings. Previously at common law, the position is that no amendments of pleadings would be allowed except the leave was granted by a full bench of court sitting at the Westminster. Nevertheless, a more liberal approach was then adopted in the common law with the passage of the Supreme Court of Judicature Act 1873 that conferred the court liberally at any stage of the proceedings allowed either parties to make amendments on his pleadings, whichever is necessary for the purpose to determine the real questions of the dispute. In Cropper and Smith, the English court initiated that the primary rationale to allow amendments of pleadings is to protect the overriding interest of justice of the parties from unintentionally mistake made by them in the pleadings. As regard to the Malaysian positions towards the amendment of pleadings, it indeed follows the common law position, whereby the rule of courts 2012 allows the litigants to amend their pleadings if necessary to cure any irregularities or omissions made during the initial pleadings. By referring to the Order 20 of the Rules of Court 2012, it is pertinent to note that there are three circumstances in which the parties can amend their pleadings inter alia without the leave of court under Rule 3, with leave of court under Rule 5, and finally by written agreement between parties under Rule 12. According to Order 20, Rule 3 of the ROC, a party may amend any pleadings once at any time but before the close of pleadings, and where he does so, he shall serve the amended pleadings on the opposite party. However, the parties who amend the pleadings under this rule shall not add or substitute parties or bring a new cause of action within the amendments made. Meanwhile, Order 20, Rule 5 of the ROC confers the parties a right to amend the pleadings at any stage, even after the close of pleadings with the leave of court. Unlike stipulated in Rule 3, parties may, if the leave was granted by the court, to alter the capacities in which a party sues, as well as bring in a new cause of action that arising out of the same facts. In the case of Punasami and Another versus Naturam, reported in 1959, the court has come across an application to amend the pleadings. The learned judge laid down the local proposition that no court ought to simply refuse the application to amend pleadings unless the pleadings so granted were not materially useful to the case. Additionally, in Yamaha Motor Co. Limited versus Yamaha Malaysia Sdn Bhd and Others, the Federal Court has also set up a yardstick to determine whether an application to amend the pleadings will cause injustice and to the opposite party or not, by examining whether the application was bona fide, whether the prejudice caused to the opposite party can be compensated by costs, and whether the amendments would not change the characteristics of the original suit. Whereas, in the event of an unordinary delay in filing the application to amend the pleadings, the Federal Court in Hong Leong Finance Berhad versus Lo Tiam Ho held that it is necessary for parties to give a cogent explanation for the delay incurred to prove that the application is not a mere tactical monorail. Otherwise, notwithstanding the principle in Yamaha Motor, the lateness in applications to amend the pleadings cannot necessarily be compensated by the payment of costs. In summary, the court has its liberal discretion to refuse the leave if the applications for amendments made under Order 20, Rule 5 of the ROC is mere tactical monorail, or is made in bad faith to cause prejudice to the opposite parties or delay the proceedings. Moving on, the amendments of pleadings made under Order 20 Rule 12 of the ROC is rather straightforward, in which the amendments of pleadings, including the course of action, may, by writings of agreements of all the parties, be amended before the commencement of the trial. Yet, it is noteworthy to note that if a party wishes to make an amendment which consists of an additional or substitution of a parties, he shall still need to pursue his action under Order 20 Rule 5 of the ROC to seek leave from the court. Finally, we reach the last part of the presentation today, in which we will cover the consequence of the amendments of pleadings to the opposite party. Accordingly, Order 20 Rule 3 of the ROC stated that when the parties was served with the amendment pleadings, he shall have the equal opportunities and right to amend his reply to and serve it within the periods of 14 days after the amended pleadings was served on him. Moreover, Order 20 Rule 4 Sub-Rule 1 of the ROC thus also provides a redress to the opposite party in which he could actually oppose an amendment of pleadings made without leave within 14 days after the amended pleadings was served on him. In deciding the application to disallow an amendment, the court was actually guided by Order 20 Rule 4 Sub-Rule 2 of the Rule of Court. According to this rule, the court shall disallow the amendments if the amendment will not be allowed as if we proceeded under Rule 5. In conclusion, the amendment of pleadings no doubt provides a golden opportunity for the litigants to avoid any impediments to their case due to unintentional mistakes that made. Nonetheless, the amendments of pleadings must not be viewed as a convenience for the litigants to inevitably prolong the pleadings.